Today, for a change, we won't be looking at border exceptions, though we are going to have an update on those. Instead, with just 10 days to go before it takes place, we finally have the operational manual changes for the retiring of the work to residence visas, the talent accredited employer visa, and the long-term skill shortage visa, and how this is going to impact those of you who are on those visas. However, there is some good news, finally some good news for some of you who are stuck offshore, although again, only those who are on those talent accredited employer and the long-term skill shortage visas. It is 5:47 p.m. here on Friday, 22nd of October 2021. My name is Arran Hunt. I am a partner at the law firm Stace Hammond here, where I head up the immigration team. As always, this is not legal advice. This is just our commentary on immigration here in New Zealand. Looking for legal advice, please get in contact with us. And as always, please again, like this video if you find it of use. Please share it amongst other people. Subscribe if you want to hear about our future videos when they do come out. They come out generally on a weekly basis, give or take how busy things are in immigration. First, we're going to cover two quick things that have happened today. Now, first thing is this happened yesterday, I believe. The long-term viewers of these videos will know that we have been advocates for a long time for those working in health during COVID-19, and we've had a fight that around the partners of work visa holders coming to the country, and of course we finally actually got some movement on that some time ago. Now, after months of issues for critical health workers having to struggle to get into New Zealand due to the MIQ issues, the Minister has announced there'll be 300 spaces for critical health workers in emergency MIQ per month. Now, this is great, but it's months overdue. It should have happened months ago. We've seen athletes and entertainers getting emergency MIQ. So why must nurses and doctors need to wait when they aren't is just beyond us. There is a border exception allowance. There has been a border exception allowance for emergency MIQ that kind of covered critical health workers, but clearly it was so difficult to get that the Minister felt he needed to come out and just say 300 per month right there, emergency MIQ. Let's get the nurses and doctors and the other health workers into the country. So fantastic news, but probably a year too late. The second thing was the Prime Minister today announced in a very rare 10 a.m. press conference the new steps going forward to opening up the country and how things are going to take place over the next month or two. Now, there was no dates for the border itself, but it is a move from what is currently a 4-step system or 4 levels with different levels within that. Which got kind of complicated when you had all these sort of sub-levels and changes and sorts of things. So they're going towards a less complicated traffic light system where you've got sort of red, orange or amber and green. Now, Auckland goes to red away from the current level 3 standard when we reach 90% of the Aucklanders who are eligible for vaccination to be double vaccinated. Which we're hoping will be in the next month or so. The rest of New Zealand will go to orange or amber when the rest of the country reaches 90% of the eligible people being double vaccinated. Which will probably likely be after Auckland. Auckland is sort of leading the pack when it comes to vaccinations as a whole against the rest of the country. Now, on the end of November, November 29th, the government will review that just in case they haven't hit that goal yet, and they may open it up then anyway if that goal isn't going to be reached, but they're going to review it again. So that's what, about 5-6 weeks away. The South Island may be released earlier than that, may go into a green or an amber status. Prior to that, they are currently on level 2, as is most of the North Island. So at least we know where we are now, where we are sort of going. The government has effectively agreed that we can't get rid of Delta out of the country, but they're still wanting to limit the amount of death and harm that Delta can cause, or COVID can cause as well. Now, on that point, I want to just mention, because we've had a lot of sort of things going around about, was it worth this lockdown? Was it worth doing this? and there's always going to be yeses and nos and sort of arguments either way. One thing to point out is that New Zealand has had 5 deaths per million people, 183rd out of 194 countries, according to a quick check on Wikipedia. The UK, who we keep getting compared to about the idea of opening up, now the UK has had over 2,000 deaths per million. We've had 5, they've had over 2,000. And actually the UK, the way they count their deaths, it should be higher than that because they count their deaths in a more restrictive way than we do. So the government is attempting to do what it can to start to open up without having our numbers going crazy like they have been in other countries. And I think that's probably possibly the best way to go. I think there's has to be some sort of balancing out between the two factors. Now, okay, on to our main topic. The work to residence visas have been a visa that have covered a number of areas, providing people who have work in certain areas or for certain accredited employers a pathway to residence. It has been largely hampered for some time by the slowdown created by the reduction in the residence numbers that the government made 3 years ago, with massive delays in many applications from residents from work visas being processed. They're waiting sort of a couple of years once they apply to actually get the visa looked at by an officer. The largest proportion of people on work to residence came through with a job with an accredited employer. And accredited employers were employers that had provided to proof to Immigration New Zealand that they had good employment practices. They tried to hire and train New Zealanders, but they needed to bring in a certain number of skilled staff that they couldn't find locally. So Immigration New Zealand would give them accreditations. About 1,000 or just over 1,000 employers in New Zealand at any one time that had that status. So these were visas that were easily obtained for their staff by these employers. And they had other advantages, like there was no IELTS, no English language requirements for those who were going through this pathway. So it was often a better pathway for those who were highly skilled but may have had trouble meeting that IELTS standard. Now, applying for accreditation by the employer, it was a yearly process, but that process ended at the end of June when the last applications were allowed to be submitted. From 1 July, there's no more applications for accreditation by employers, meaning that companies have started to now lose that accreditation. Now, many employees looking at years of waiting, sitting in queue for residence, or now possibly going to apply for the, on 1 December for the new one-off S6 residence visa, need to be able to apply for another work visa just to remain in the country lawfully. And this is where the changes largely come in, how they're going to handle these applications for people who have been on this visa, now that the visa is being sort of turned off and shut down. Employers are losing their accreditation as they're unable to keep it current because they can't apply for a new one, but the employees need to still be able to retain that visa so they can continue with the pathway to residence. So let's look at the changes being made. Just going to bring it up on the screen here. Now we'll look for the changes here. The first lot we'll look through are current. They were announced today. We got this document just about 2 hours ago. But they've been in effect since 20 of October 2021. This is Amendment Circular 2021-47. It will be available online on the immigration website in the next couple of days and integrated into the operational manual in the next week or two. For those of you who are new, the operational manual is the rules that Immigration New Zealand follow when in deciding an application. So if you hear me refer to a letter and their number, I'm referring to the operational manual, and you'll see me looking at those as we go through this document. Now, so the main changes here appear in WR110. They're highlighted in yellow, so you can see where the changes are. We'll come back to those ones in a moment. WR110.1, which states that an accredited employer work visa can be granted for an employer who is no longer accredited as long as they were accredited when the work visa application was lodged. So for those looking to gain a, so this is for those who have applied for a work to residence visa, and it, as long as you apply prior to the accreditation expiring, that application can proceed. For those looking to get a second work to residence visa while they sit in queue, WR131 covers that. Here it is here. For those of you looking to apply for a subsequent work visa, so you can maintain your visa status, WR131 continues to cover that. As long as you're applying for the same employer that is supporting the residence application. So you need to have a residence application in play when you do apply for this. Of course, you should have that done because you have a 6-month period to get the application in place before you require this next visa. Now, for those of you who are looking to vary your terms of your work visa to work for another employer, that is what the E326.110 is for up the top of the amendment circular. It allows for those where the company is either still accredited or they held accreditation on 31st of March 2021 and it has since expired. It also applies where the variation of conditions was applied for prior to these changes coming into effect, but not yet been decided yet, which is seen here in sub-point C. So if you've applied for a variation perhaps a couple of weeks ago and your employer's accreditation expires after before your decision is being made on your application, this will still apply because of sub-point C here. And then, okay, now we're going to look at the changes made for residence applications. This is one here. So this can affect from the 20th of October, so 2 days ago. These are more limited, but likely to be of little point to many of those in the queue, as most should now fall under the one-off F6 residence visa and can apply for that on 1 December 2021. But for those of you who can't, for some reason, apply for that or want to stay in this queue for some strange reason, they have updated WR2 to allow for residence to be granted where the employer is no longer accredited, where the visa was granted to work for that employer. So there's a work visa for that employer. You can apply for residence with that employer despite them no longer being accredited because it has expired. And sort of repeated through there as well. Now, finally, there's some changes here that are coming into effect on 1 November. Now, 1 November, of course, is the date after which you can no longer apply for one of these talented accredited employer visas. So we're going to look through these now. It also has some good news in here as well. So WR 1.5 again repeats what was said previously, that the applications must be made before 31 October to be able to apply for the talented accredited employer work visa. Strangely, it doesn't include the year there, which is an oversight. There should be 2021 there, just to clarify which year it is. We know what year it is now, but when you're looking at this sort of in the future, looking back to previous instructions, you'll probably want to have 2021 written in there. Now, as per WR 130, of course, applications received after that date will not be accepted, though this doesn't apply for subsequent visas when someone is replacing their current visa. Now, we'll get to the most significant change here. So here we have, again, a change here. It mentions the same sort of thing, cannot apply after 31st October. And this, again, here is the allowance for the subsequent work visas. Now, here is the most significant change here. WR 130.5 allows the people who are caught offshore to continue their pathway to residence by allowing for a new visa to be granted. Now, the requirements listed here are that they left New Zealand prior to 19 March 2020 and return after 31 October 2021. So they need to be offshore at the moment and offshore until at least another 9 days. But they must be in New Zealand when the application is made. So this is generally aimed at people who find a way into New Zealand, so likely will only have impact when the border opens. They're required to have an offer from an employer who is accredited or who supported a previous talent visa or held accreditation after 31st of March 2021, which has since expired. So if you've worked previously on a talented accredited employer, because this is a subsequent work visa, for those of you who have already been on this visa previously, this allows you to get in there as long as you meet one of those 3 criteria, well, your employment meets one of those 3 criteria as to who you're employed by. And of course, you're required to have an offer that meets the requirements, which is generally 24 months at least. The base salary that was placed when you apply for your initial visa, of course, those salary thresholds went up and meet the general requirements for this application. So this gives those offshore who are on this visa type a chance to get onto it again. The 24 months requirement before you apply for residence does restart, which is a shame, but that's the way they decided to do it. And you need to be onshore. So this isn't an easy answer for those people who are offshore, at least not yet. But when the border opens, it will give you a chance to get back into that pathway to residence. Now, WR 3.1 brings the long-term skill shortage visa to an end on 3 October. Again, here they've actually entered the year rather than just putting the month and the day. This is a repeat of WR 315. And then WR 315.5 provides the same allowance for those who are stuck offshore to be able to apply for a further long-term skill shortage list visa in their pathway to residence. So that gives those of you who are offshore in that position options going forward once the border is open. And similarly, there is changes to the residence instructions to allow these applications to be made in the future. And that is it for today's video. I know that that will be a little bit bittersweet for some of you who are offshore, who may feel that you are still being forgotten about. I encourage you to think of this perhaps not as being forgotten about, but seeing that Immigration New Zealand is now taking those first steps into providing a pathway for those who are offshore. There is still a lot of work to go, but this is at least it's a step. It's not a big step, but it's something for those of you who are offshore who will fall under these new sets of rules as a way to continue your pathway to residence and your life here in New Zealand. It does require the border to be open, but it just shows that immigration is preparing for that day to take place at some point. That is it for me today. We'll come back to you when we do have more. We are expecting to have the S6 one-off residence visa rules at some point in the next week or so. We'll be doing a number of videos covering those because that will be a rather large thing to break down. Until then, kia kaha and stay safe.